they have a law that applies to them, the Privacy Protection Act, which was passed in 1980 after the Supreme Court issued a ruling that maybe threatened the rights of journalists. And the law protects journalists and authors and scholars who plan to disseminate information from the government, and it protects them from government searches and seizures of their work product and the materials that they have. The law requires that law enforcement use a court-approved subpoena first and not a search warrant first. The reason for that is that they want to protect journalists from prior restraint and also from invasion of their secret sources, which are very important to journalists. And subpoenas would safeguard the First Amendment rights because that would allow the journalist to go to court and say, whoa, there's no reason for this, and I can tell you why they're coming after me, and this has nothing to do with anything. So it would protect the journalist or the author or whoever is being searched who has this information and protects the damage before it happens. Once they've done a search warrant, they have the information. And so the damage is already done. And this is like analogous. Remember when we had Michael Cohen's records being seized, which had attorney-client privilege protections. This has certain First Amendment protections. And the court said, you can't just use it. They appointed a special master to review what stuff was protected by attorney-client privilege. And I think that's important to keep in mind.